Welcome. For those of you who don't know me, I'm Steve Wallenstein, the director of Duke University's Global Capital Markets Center. We are delighted that you're able to join us today for what promises to be a very stimulating and provocative discussion about a critically important global issue. In addition to welcoming those of you who are physically present in this new high-tech classroom here at the Duke Law School, let me give an enthusiastic welcome to those of you who are joining us in virtual reality. The webcasting of today's workshop marks a first for our 2-year-old center. Before introducing our keynote speaker and distinguished guest panelist, I'd like to briefly tell you about the center and what we do. Founded in 1998, the Duke Global Capital Markets Center represents a unique collaboration between Duke's law and business schools. Through the center, faculty from both schools are developing new and innovative courses in international law, business, and finance, and are offering conferences, workshops, and programs designed to prepare future leaders in international law and business. With the combined expertise of several disciplines at its service, the center is mapping new territory.
David?
Yes. Okay, hello, he should be on.
David, hi, this is Steve Wallenstein, Steve Schwartz.
Hi, how are you?
How are you? Nice.
I'm having trouble connecting to the webcast. Do I have the address wrong? Or, www.law.duke.edu/webcast/live-rent?
That's right.
Well, they're like, it doesn't like that.
We just started the webcast a moment ago, so there will be some delay time. I recommend that you turn your computer down and just listen to the webcast so you won't get an echo and a substantial delay.
Okay.
Thank you.
The Duke Global Capital Markets Center, with the combined expertise of several disciplines at its service, the center is mapping new territory in understanding capital markets and their global connections. In addition, the center is providing information and guidance through international conferences and training seminars on best practices for developing capital markets in emerging economies. We are honored today to have with us several Duke scholars whose research and publication in public policy and law make them uniquely qualified to comment on the ideas that will be presented by Professor Schwartz. With us today is Jacob Vigdor, who is an assistant professor of public policy studies at Duke University's Terry Sanford Institute of Public Policy. He received his PhD in economics from Harvard University in 1999 and has come to Duke to continue his research on state and local public finance, the economics of urban and social issues, real estate and mortgage markets, as well as applied econometrics. His recent publication, The Rise and Decline of the American Ghetto, which he co-authored in the Journal of Political Economy, examines the social forces promoting segregation. Professor Vigdor, welcome. Unfortunately, the second commentator, Professor Keohane, who was supposed to be with us here today, was unable to make it because of a last-minute conflict. It is now my pleasure to introduce our keynote speaker, Professor Steven Schwarcz, Professor of Law at Duke University and the Faculty Director of the Global Capital Markets Center. A 1974 graduate of the Columbia Law School, he has had extensive experience as a partner in 2 leading international law firms, where he represented many of the world's top financial institutions in structuring innovative financing transactions. As a practicing lawyer, Professor Schwartz pioneered the field of asset securitization, which the Securities and Exchange Commission has described as becoming one of the dominant means of capital formation in the United States and more recently abroad. While practicing, he taught courses in bankruptcy, corporate reorganization, commercial law, and structured finance at Yale, Columbia, and Cardozo. Since coming to Duke in 1996, Professor Schwartz has worked closely with colleagues at Duke's Fuqua School of Business and is the founding faculty member of the Global Capital Markets Center. His monograph, Structured Finance, A Guide to the Principles of Asset Securitization, is the most widely used text in the field of inventive commercial finance. He is an advisor to the United Nations on international receivables financing and cross-border insolvency. He is a member of the U.S. Secretary of State's Advisory Committee on Private International Law and is a fellow of the American College of Commercial Finance Lawyers. He has taught in the Asia-America Institute in Transnational Law, which was co-sponsored by Duke and the University of Hong Kong. He has lectured extensively on commercial and financial law subjects at the University of London, Cambridge, and the Catholic University of Chile. In recognition of a scholarship in bankruptcy law, Professor Schwartz was elected by Hofstra University Law School to give the 1996 Benjamin Weintraub Distinguished Professorship Lecture. Today we will hear Professor Schwartz speak about a possible solution to an alarming global problem, the municipal debt crisis that is now pandemic, affecting municipalities not only in emerging economies, but also impacting locales in many of the world's most developed countries. Today's presentation builds upon ideas that Professor Schwartz first presented at an earlier Global Capital Market Center workshop, Sovereign Debt Restructuring, held here at Duke in April of this year. That article was later published in the May 2000 issue of the Cornell Law Review. In that talk, Professor Schwartz proposed a solution to how nations could address the debt problems when no legal system presently regulates the relationship between debtor nations and their creditors. Professor Schwartz proposed that sovereign debt restructuring should be subject to supranational regulation and proposed adoption of an international convention for sovereign debt restructuring based on bankruptcy reorganization law principles. Today, Professor Schwartz will discuss how his concepts for addressing the problem of sovereign debt restructuring may be applied to similar problems faced by municipalities. He notes that there are no easy economic or political answers to the problems of subnational debt restructuring. Professor Schwartz will show how this problem is well suited to a legal solution based on the fundamental principles of bankruptcy reorganization law. He proposes a model law based on those principles. The appealing feature of his proposed solution is that it can be tailored to be compatible with the legal system of any country. Much of his current research has focused on the municipal debt crisis in Japan, but as we will hear, is not limited to that country only. Please join me in welcoming my distinguished colleague, Professor Steven Schwarcz.
Thank you, Professor Wallenstein. It's a pleasure to be here, and thank you all for coming. I know there are the Supreme Court hearing is going on, and I really appreciate your being here. And thank you for Professor Gelfand for joining us by conference call. According to the World Bank, decentralization is one of the two forces, the other being globalization, that will shape world development policy in the 21st century. Even now, governments are shifting numerous public responsibilities, including construction of new capital projects, to the subnational or municipal level. To meet these responsibilities, municipalities worldwide are raising funds by issuing domestic and foreign debt. But it's becoming increasingly difficult for municipalities to repay all this debt. As a result, the problem of subnational debt restructuring has become pandemic. The worst problems today are in Japan, where the overall municipal financial deficit, and I quote, is at the highest level ever seen in the world, and matters are only expected to get worse. But Japan is merely the tip of the iceberg. In Central and Eastern European countries, municipal debt financing is leading to deficits that will exceed 10% and deteriorate further over time. Russia faces a significant deterioration of the cities' and regions' fiscal and debt positions. In Brazil, decentralization has resulted in a prolonged macroeconomic crisis sparked by the growing indebtedness of the subnational states. Existing or potential concerns also have arisen in Mexico and Argentina. Yvonne, do I look into there or do I look there? What would be for the webcasting?
Work your all view.
The problem also extends to municipalities in many of the world's most developed countries. In Switzerland, Italy, Spain, France, Germany, the Nordic countries, and the United Kingdom, for example, there have been many cases of localities getting into financial distress, even defaulting. A number of major municipalities have even recently defaulted in this country, the United States. For these reasons, the World Bank has identified subnational debt as, and I quote, one of the thorniest issues for decentralization. Now, there are no easy economic or political answers to the problems of subnational debt restructuring. If central governments were to prohibit the issuance of such debt, that would only shift the financing burden to national levels while limiting municipal flexibility to finance locally attractive projects. A central government also could attempt to restrict the amount of debt that municipalities can issue, but restrictions don't always work. Consider, for example, that Japanese municipalities are near default even though municipal bonds in that country are issued, quote, according to ordinances and permits in order to maintain the soundness of the financial operations of local public entities, and the annual amount of local bonds issued is controlled through local bond programs created by the Ministry of Home Affairs. Is that okay in that connection? David, can you hear us okay?
Yeah, I can hear you, okay. I just was never able to connect with the website.
Okay.
It just kept saying it wasn't available.
Okay,
So, but I hear you fine on the phone.
good. Municipalities also cannot rely on taxes to repay their debt. At some point, an increase in the tax rate will be counterproductive. Some citizens and businesses will be unable to pay the tax increase, and even those able to pay may instead choose to leave the municipality, causing the economic output to decline. Should the central government support its troubled municipalities, this can create a moral hazard problem. Municipalities anticipating such support might have less reason to take a prudent economic course and be less cautious in incurring debt. And their creditors, expecting protection from the consequences of default, might be less prudent in making their credit analysis. Even in Japan, experts believe it's best for municipalities and their investors to be disciplined by market principles. Moreover, central governments may not want or even be able to support subnational debt. Because of the weak financial state of the Japanese central government, for example, the Japanese Ministry of Finance, quote, is negative on shifting tax resources to local governments. Absent an economic or political solution, municipalities and their creditors will be forced to attempt to restructure their debtor-creditor relationships on a consensual basis. This, however, is difficult to achieve. The conflicting interests of the municipality and its creditors make it difficult, sometimes impossible, to reach agreement on a restructuring plan. This difficulty is exacerbated by the collective action problem. That is, a problem of reaching agreement among creditors. This problem, which indeed has worsened in recent years, as municipalities have been shifting their borrowing from domestic sources, such as banks, to bond investors in lower-cost foreign capital markets. One or more creditors may hold out, hoping that the need to reach an agreement will motivate other creditors, other parties, to buy out their claims or pay them a premium. There is therefore need for another solution. I propose a legal solution. Historically, legal solutions have not always been adequate. Japan, for example, has tried several legal solutions, but these solutions all depended on the central government being willing and able to subsidize its municipalities, a dependence that has and may backfire. These solutions all contemplated paying creditors in full, notwithstanding that creditors have assumed the risk of default, and that such payment could force a moral hazard on the part of future creditors. And Japan's legal solutions, none of them address the collective action problem of debt restructuring. I believe, however, that subnational debt restructuring is well suited to a legal solution. Consider that if a company fails to pay its debts, a system of corporate bankruptcy, or insolvency law as it's known around the world, usually governs the relationship between the debtor company and its creditors. In contrast, if a municipality fails to pay its debts, few countries have legal systems that govern the relationship between the municipality and its creditors. This absence is regrettable because, as I next show, bankruptcy reorganization law principles can help to solve the problems of collective action and moral hazard, as well as similar concerns, even in a subnational debt restructuring context. My analysis first examines the conceptual basis of bankruptcy reorganization law, especially Chapter 11 of the U.S. Bankruptcy Code. Then I analyze how that conceptual basis should be modified to address subnational debt restructuring and its problems. My methodology risks being incomplete. For example, the conceptual basis of corporate reorganization under the insolvency law of the country in which a given municipality is located might be better suited to that municipality's debt restructuring than Chapter 11 of the U.S. Bankruptcy Code. Nonetheless, my examination of corporate reorganization under several foreign insolvency laws has revealed that the conceptual basis of these laws is remarkably similar to that of Chapter 11. This indeed is consistent with recent scholarship, which predicts, and I quote, that it is highly likely, if not inevitable, that countries that have market economies will develop bankruptcy reorganization systems that function in essentially the same way because the functional aspects of those systems are shaped not by culture or politics, but by necessity. In any event, the analogy to Chapter 11 serves only as a starting point for inquiry. Next, I'll consider what the conceptual basis of Chapter 11 is. There is disagreement on this. Traditionalists argue that Chapter 11 attempts to rehabilitate viable debtors and ensure equality of distribution among creditors. Free market scholars, however, argue that the only normative goal of bankruptcy reorganization law should be economic efficiency. These contrasting views represent distinct and possibly irreconcilable philosophies of corporate reorganization which arise out of different starting axioms. There are three disputes. The first dispute addresses the rehabilitative role of bankruptcy law, questioning the role the law should play in keeping a firm intact as a going concern. This dispute does not apply to subnational debt restructuring because, at least in the present world order, it is not politically viable to liquidate a municipality. The second dispute concerns whether bankruptcy law should be a closed or an open system. Free marketers believe that bankruptcy should be an open system, meaning that its rules should minimally affect pre-bankruptcy incentives. Traditionalists, on the other hand, believe that the breathing space that bankruptcy law gives distressed firms and the other costs it imposes on the participants have only a modest effect on how creditors and others behave ex ante. This dispute does appear relevant to subnational debt restructuring. Municipalities may well need breathing space to reorganize. Therefore, subnational debt restructuring rules should be crafted to balance the need for breathing space with the goal of minimally affecting pre-restructuring incentives. The third dispute concerns the implementation of bankruptcy law and focuses on the judge's role in the bankruptcy process. Free marketers see the parties making their own decisions, the judge acting simply to ensure that the biases of the parties are taken into account and all relevant information is disclosed. In contrast, the traditionalists believe that implementing the goals of bankruptcy requires investing the judge with broad discretion to ensure that bankruptcy's goals are vindicated. This dispute is also relevant to subnational debt restructuring because issues of discretion may arise. Nonetheless, granting judicial arbiters broad discretion to bind municipalities is likely to be politically unacceptable. Accordingly, any framework for subnational debt restructuring should attempt at least to minimize adjudicatory discretion. Therefore, a final framework for a legal framework, for subnational debt restructuring has at least three normative underpinnings. One, it should foster, or at least not impair, the municipality's ultimate economic rehabilitation. Two, it should balance the need for breathing space with the goal of minimally affecting pre-restructuring incentives. And three, it should require minimal adjudicatory discretion in its administration. Moreover, any complete framework must address the major problems associated with subnational debt restructuring, including collective action and moral hazard. A next attempt to use this framework to fashion rules that might form the basis of a subnational debt restructuring law, which I sometimes refer to as the model law. I do this by identifying the provisions of the bankruptcy code that might be relevant to subnational debt restructuring, and then by analyzing those provisions in light of the proposed framework. I'll illustrate this by two examples. The first example is reorganization financing. Section 364 of the Bankruptcy Code outlines a procedure for a debtor to obtain financing for its reorganization from the credit and capital markets. This is commonly referred to as debtor in possession or DIP financing. In order to attract DIP financing, the Bankruptcy Code gives priority to lenders and investors that provide such financing. Without priority, financing would be unavailable because new financiers will not want to be taxed or basically have their claims diluted by the claims of existing creditors. The need to grant priority in order to attract credit and capital market financing is at least as compelling in a municipal as in a corporate debt restructuring context. A financially troubled municipality will need fresh working capital during its restructuring so its critical government functions don't collapse. Without a priority, however, municipalities could not obtain such financing. Therefore, troubled municipalities look to their central governments as lenders of last resort. But shifting the source of funding from the central government to the private credit and capital markets would reallocate the burden from the central government to the municipality and its creditors where that burden belongs. Although the size of the credit and capital markets is clearly large enough to accommodate the legitimate financing needs of restructuring municipalities, a municipality will have no assurance that private credit will be available. This risk of potential default therefore will make the municipality more careful when obtaining credit outside of a debt restructuring proceeding, and arguably more disciplined in its economic planning. Creditors also that lend to a municipality outside of such a proceeding will face the same risk of default. They too will lend more carefully. I show that granting a priority appears neutral from the standpoint of collective action, and that the adverse effects on pre-restructuring incentives should not be excessive from the standpoint of either the municipality or its creditors, with one exception, and that is that new money priority credit could decrease the value of creditor claims if overinvestment occurs. By overinvestment, I mean that the proceeds of the new money credit are invested in a less valuable project. In a corporate reorganization context, the Bankruptcy Code discourages overinvestment by allowing creditors to scrutinize and object to excessive amounts of DIP financing. Creditors should have similar rights to object to any priority financing in a municipal debt restructuring context, and where it's not economical for creditors to scrutinize the funding, the central government itself should step in and do so. Furthermore, to reduce moral hazard, the central government should have the right to impose conditions when appropriate on funding. This approach is known as conditionality. Conditionality could require, for example, that the municipality prepare a financial plan, an approved budget, charge more for the use of its public facilities, or reduce its municipal services. But allowing the market to work creates a risk that a municipality might sometimes be unable to obtain private market funding, even by offering priority, thereby forcing the municipality into default. Default arguably might be justified where it provides a needed signal to motivate other municipalities to maintain their fiscal and economic integrity, not to issue debt beyond their ability to repay. Ultimately, however, the matter of a central government bailout of a municipality will be a political question. The second example I'll mention is what's called supermajority voting. Section 1126 of the Bankruptcy Code, I should explain that my references to the Bankruptcy Code in Chapter 11 also includes other chapters of the Bankruptcy Code such as Chapter 9 that deals with the reorganization of municipalities. There is a specific chapter in U.S. bankruptcy law, but that chapter has virtually no independent substantive provisions and merely incorporates various of Chapter 11's provisions. So I refer simply to Chapter 11, but it's understood to include the entire bankruptcy code. Section 1126 of the Bankruptcy Code provides for a form of supermajority voting that supersedes contractual or statutory restrictions. For example, loans are often made by groups of institutional lenders, such as banks or insurance companies, that typically require unanimous consent of the lenders in order to alter essential lending terms. For example, the amount of principal, the rate of interest, or the maturity schedule. 1126 overcomes the collective action problem by altering these terms by providing that a supermajority vote of creditors binds all creditors, even those that dissent. In contrast, subnational debt restructurings that change essential lending terms still require unanimous creditor approval, which is difficult and sometimes impossible to achieve. Supermajority voting can solve this problem for subnational debt restructuring. I show that this voting scheme is neutral from the standpoint of allocation of the burden, that it fosters economic rehabilitation to the extent it permits a municipality and its creditors to agree more rationally on a debt restructuring plan, and that it also can be applied without exercising adjudicatory discretion. The only potential drawback is that supermajority voting would affect pre-restructuring incentives by modifying voting procedures that require unanimity. But that impact should be economically insignificant if, as under the code, the supermajority voting is done by classes of claims that are substantially similar, that is, pari passu, or of equal priority, to the other claims of such class. A vote by holders of this requisite supermajority therefore should also benefit holders of substantially similar claims. Based on this analysis, I propose a model law that comprises the following rules. Number one, only a municipality itself and not its creditors may commence the debt restructuring proceeding and must do so in good faith. Two, commencement of such a proceeding automatically stays all debt recovery actions against the municipality, but interest will continue to accrue on creditor claims. Three, financiers of the municipality's debt restructuring have priority over claims of other creditors, but the central government may scrutinize and object to an excessive amount of new priority financing and condition and monitor its use as appropriate in order to prevent overinvestment. Four, all creditors are bound to a debt restructuring plan that is agreed to by supermajority voting by classes of claims, and upon such agreement, debts not provided for in the plan are discharged. And five, the central government may dismiss the debt restructuring proceeding for cause, such as bad faith or unreasonable delay in reaching a plan. I don't claim that this model is the only model, or even the best model, logically consistent with this framework. The primary goal of my article is to illustrate the importance of imposing conceptually sound rules on subnational debt restructuring, not to impose definitive rules. Next, I analyze implementation of this model law and address these implementation issues. There are three. Number one, how the model law should bind a municipality's creditors. Two, how the model law should be administered. And three, how questions arising under the model law should be adjudicated. As to the first question, binding creditors, enactment of the model law into national law would, in most jurisdictions, bind a nation's municipalities and domestic creditors. To the extent a municipality's national law governs contracts and instruments under which the municipality incurs debt, foreign creditors also would be bound. Sometimes, however, the municipality's national law does not govern the debt contract. How can those foreign creditors be bound? The answer is both theoretical and pragmatic. Municipalities rarely own assets outside their country. Therefore, foreign creditors attempting to enforce their claims against the municipality would have to do so in the municipality's national jurisdiction. If that nation has enacted the model law, the provisions thereof arguably would reflect the nation's fundamental public policy of preserving the integrity of its municipal governments. And indeed, the model law I propose explicitly articulates that its provisions represent the nation's fundamental public policy. Under conflicts of law rules that are common to most countries, a nation is not required to apply a foreign law if application of that law would result in a violation of the nation's fundamental public policy. That might occur, for example, by permitting enforcement to continue, notwithstanding the stay, or by challenging the priority of the debt incurred as part of the reorganization. As a practical matter, too, foreign creditors could not actually enforce their claims against municipal assets unless the nation acquiesced. A nation that wishes to protect its municipality's assets therefore could simply refuse to allow those creditors to pursue their claims, except in accordance with the model law. This would not violate public international law because the model law requires that foreign creditors be treated no worse than domestic creditors. Second implementation issue with administration, at least in a country debt restructuring context, some scholars have assumed that a neutral entity, effectively the equivalent of a bankruptcy court, is necessary to administer the debt negotiations. I show that such an entity is unnecessary. These negotiations will be largely self-executing because they take place in the shadow of the model law. A municipality also has little room under the model law for strategic manipulation. Consider, for example, if an economically healthy municipality commences a debt restructuring proceeding in an attempt to take opportunistic advantage of its creditors. Those creditors, first of all, could challenge this proceeding as lacking good faith, and if they win on that challenge, the proceeding would be dismissed. Even if they lose on the challenge, the municipality would have little ability to manipulate the law unfairly to their disadvantage. Existing creditors would not be harmed because the municipality, being economically healthy, would be able to repay all of its creditors. And indeed, the model law I propose includes not only the accrual of interest, but also the compounding of interest, that is, the accrual of interest and overdue interest. Whether or not economically healthy, a municipality would be unable to manipulate the use of loan proceeds because priority loans are monitored to prevent overinvestment. And also, the requirement of supermajority voting by classes of claims gives veto power to each voting class, thereby preventing a municipality from devising a plan to harm individual classes of creditors. The central government's role, therefore, would be limited in most cases to objecting to excessive amounts of priority funding and, where appropriate, imposing conditionality. The final implementation issue is adjudication. How should disputes be resolved when they arise under the model law? If municipalities had only domestic creditors, these disputes could be adjudicated by the nation's judiciary just like any other domestic disputes. The problem, however, is that municipalities may have foreign creditors. Relatively little precedent exists for a tribunal to adjudicate disputes between a country or subdivision thereof and its foreign creditors. In a subnational debt restructuring context, however, there should be little need for an international tribune because, one, a national tribune not controlled by the municipal government would have no direct conflict of interest. Two, the municipality's nation would have a strong incentive to adjudicate disputes fairly because the appearance of bias would adversely affect the availability and cost of credit for all of the nation's other municipalities. And three, foreign creditors would be protected against discrimination because, as mentioned, the model law requires that they be treated no worse than domestic creditors. The paper ends by basically applying the model law to the problems that presently are occurring in Japan, who, as I've said, municipal debt problems are among the world's most difficult. I will, however, stop here to allow our commentator to present some commentary, and then we'll have questions, and if need be, we'll go through the Japanese situation. our commentator, Professor Jacob Vigdor.
Thanks, Steve. Well, I think that this project of trying to figure out what to do about subnational governments that are running into problems with debt, I agree with Steve's assessment, which is also the World Bank's assessment, that this is an extremely thorny issue. The way that I would like to base my comments today are from the perspective that I bring to this. I'm an economist by training. Specifically, I'm a public finance and urban economist. And so when I look at this problem, what I see, there are definitely a lot of legal concerns, and these are the things that I think Steve is really trying to address with this. But I also see this as an extremely complex and very interesting problem, just in the context of designing a fiscal federalist system. So that the question that I would like to spend some time addressing is should central governments act as a lender of last resort for their municipalities and for their subnational governments? Now, I think that this question is a difficult one because there are lots of arguments that you could make on either side. And I think some of these are addressed quite adequately and completely in the paper, and there are some other ones that I'd also like to bring up just for the sake of discussion. When we think about fiscal crisis at the level of a municipal or any subnational government, Martin Schefter's analysis, which was based on the experience of New York City and their fiscal crisis in the 1970s, suggested that these fiscal crises were not aberrations, rather they were an integral part of urban politics. That a fiscal crisis at a municipal level plays a role, and its positive role is to precipitate a political crisis. In order for this to occur, however, for a fiscal crisis to precipitate a political crisis, there needs to be some amount of pain at the local level that is a consequence of your local government running into trouble. If your local government knows that it will always be bailed out by a state government or national government in the event that they run into fiscal problems, then we think that they're going to be especially prone to running into such problems. And when these problems come about, the lack of pain means that there won't be the political crisis that we would expect. Those poor managers or corrupt managers that ran into the problems, we would like them to be thrown out of office. If systems are working, we'd expect that to happen. So this is the moral hazard problem that Steve was talking about. If your local government can rely on someone else to bail them out of trouble, then they're going to be more likely to get into trouble than we would like them to be from the perspective of economic efficiency. So that's a very strong argument for keeping the central government out of the picture, because whenever the central government plays any role in bailing out a local government, we think that that's going to have poor incentives on the local government's behavior. So that's one side of the coin. And then what I'd like to spend the rest of my time talking about are three different scenarios when we might like those central governments to play a stronger role in intervening when their local governments run into problems with their creditors. So I'll get a little bit of assistance here in turning on the...
David Gelfand is...
Yes.
David, are you still unable to get the webcast?
I'm just trying again. I turned off my system. I'm trying it again, hoping that was a temporary thing. I just got a message that said that page is unavailable. And so I'm thinking maybe by now those words have worked out. I don't know.
Well, all I have on my overhead slides is text, and so I'll sort of be going through this outline. So it should be possible to follow what I'm saying, even though you can't see the
Okay, thank you for your
Sure. So, scenario number one, where we might want the national government to play some sort of role, is when we have information externalities. And let me explain to you what I mean by that. There are some cases where investors don't have complete information about the risk associated with any municipal government. So, when they're going to evaluate how risky one municipality is, they're going to look at the experience of other municipalities. The implication of this is that when one municipality, say Durham, defaults on its debt, there are implications for Chapel Hill and Raleigh and other municipalities. If Durham defaults, creditors are going to ask for a higher interest rate from other municipalities. So a default in one municipality leads to higher borrowing costs on the part of other municipalities. And I think Steve talks about this to some extent in his paper, so that municipalities, because of this information externality, municipalities have an incentive to try to insure one another, at least to some extent. Chapel Hill will want to help Durham out in some situations because they know that a default in Durham is going to have negative consequences for Chapel Hill in terms of higher borrowing costs. So, what mechanism do municipalities have to insure one another? Well, typically we think that the central government plays that role. And so the result of this situation is that there's some sort of balance that needs to happen between these conflicting concerns. This information externality says that central governments should play a positive role, but the moral hazard argument says that that role should be limited because of the bad incentives it creates. So what we have just from the information externality story is a fairly complicated situation. So a real-world example of this information externality story is something that I've done a little bit of research on: state debt and default in the canal building era, which happened around the 1820s or 1830s, when a lot of states that were fairly young states in the Midwest, Illinois, Indiana, Michigan, ran up a lot of debt trying to build canal projects, and they were expecting to finance this debt with tolls from the canals. But a few years later, the railroads came along and basically eliminated the economic rationale for canals, which led many of these states to default. Default by some states raised the cost of borrowing for all other states. So we think that the effect of this problem is to lead the states to have an interest in making sure other national governments do the right thing. So, like I said, that scenario is something that I think is addressed in the paper. Let me move on to two more scenarios where we think that the central government should play some role in helping out their subnational government. One scenario is when it's the central government's fault. There are certain situations where we think that a municipal government's problems with restructuring debt or going into default are directly caused by actions that the central government takes. So let me provide a little hypothetical example. Let's say that a municipality is going to build a toll road. The benefits of a toll road include transportation and national defense. One is a local benefit, one is a national benefit. Standard economic theory tells us that the people who pay for this project should be the people who benefit, and that's both local people and national people. So the efficient thing to do is have some sort of cost-sharing arrangement. The local government agrees to pay some of the costs, and they decide to finance their part of the cost by issuing bonds, and those bonds will be backed by toll revenue. And then the national government decides to finance its part through general revenue. Later on, the national government decides that it's going to abandon this matching program and leave the local government to complete the toll road on its own. The local government runs into problems, can't find any more financing, which means that the toll road project is going to be of inferior quality, and perhaps inferior quantity. Demand for the toll road falls below projections, the local government defaults. So whose responsibility is it that the local government defaulted? Well, in this case, we probably think it's the national government. And so one reason we might like to see the national governments have some sort of stake in what their municipalities and local governments do is because it's a commitment device. Because the national government knows that any trouble its municipalities encounter becomes their problem in the end, they'll be less likely to engage in behavior like this. So this is an interesting little hypothetical example. You might ask the question, is it really realistic? Do we actually see anything like this happening? Well, I have a couple of things that I can point to as examples of this. The New York City fiscal crisis of the mid-'70s, for example. Now, most people, if you ask them what caused that, they'll tell you, well, it was mismanagement on the part of the city's government. But there are also people who argue that the federal government and the policies enacted by the federal government helped to precipitate that fiscal crisis. In particular, the federal government had these housing and transportation policies that encouraged suburbanization and deprived New York City of quite a bit of its tax base. Secondly, the federal government enacted wage and agricultural policies that basically caused the depopulation of the South, especially in the post-war era, caused a lot of poor migrants to move to places like New York City, where they became a burden for the city's welfare systems. And additionally, the government had a lot of matching grant programs that imposed new burdens on the government of New York City. So in this sort of situation, we see that New York City's problems are partly the result of things that the central government did. So we might want the central government to take some responsibility for that. Another example that I can think of comes with property tax limitations, such as Proposition 13 in California and Proposition 2.5 in Massachusetts. In this situation, you take the local government of a city like Cambridge, Massachusetts, which didn't want a property tax limitation to pass. However, it was forced to reduce its property tax rates because of the actions of other voters in the state. So if Cambridge, Massachusetts defaults on its bonds as a result of a tax limitation, we don't necessarily think it's their fault. It's the fault of other voters in the state. And we might, in that case, want to make them responsible for the consequences. The final scenario that I'd like to talk about, I'm going to refer to as the approve then move scenario. So if we think about what the objective of a debt restructuring plan is, it's to basically distribute the pain in an optimal way. What we would like to do is make sure that when local governments run into trouble that they do feel some pain. And the reason for that is because it provides them with incentives to avoid that situation. The problem is, how do you ensure that local voters will feel the pain of restructuring? You might think that imposing a restructuring plan will cause this pain on local governments to be transferred to voters. But of course, anytime we're dealing with a subnational government, the voters have the option of moving. So if a municipality runs into trouble, the voters can always cut their losses by just moving away. They can just switch to it, especially if we're talking about a jurisdiction of relatively limited size. It's easy for those voters to move somewhere else. So even if we're trying to create good incentives for local governments to avoid bad projects that might lead to default, it's a little bit more difficult to transfer these incentives to voters. And how does this turn into an advantage for higher levels of government? Why is this a justification for central government intervention? It's because these higher levels of government do have the power to track these individuals down. If they approve a risky project and then leave, the central government has the power to maintain some degree of liability for these former residents. So an example of this that I would consider is the Seattle monorail project, which was approved by voters in 1997 over the objections of city government. This is a project that voters want, but the city government itself thinks it's too risky. If this project goes forward and leads to some sort of debt restructuring problem, the city government of Seattle is probably in hot water. But the voters of Seattle who actually approved it can always avoid the trouble by moving out of town, moving to one of the suburbs. So what we have at the end of the day is an extremely complicated problem. And just figuring out what role you want the central government to play in these municipal and other local government problems, I think it's definitely a very complicated, very interesting problem, but the answer is really something that we'd like to know. So I think this is very interesting work. And that'll do it for my comments.
Thank you.
Don't know who I'm handing off to now.
Questions and answers from the audience. Yes, Professor DeMott.
Yes, I'd like to identify another form of central government involvement that either Steve or Jake talked about, as to which there are at least illustrations that come to my mind, one from the United States and one from Great Britain, which is a judicial declaration that the subgovernmental unit lacked the authority or the power to issue the debt. For example, in this country in the Pacific Northwest, the Supreme Court of Washington held that whichever municipality it was, or perhaps it was a power authority, lacked authority to issue a particular kind of revenue bond to support construction of a nuclear power plant.
Yes, this was the Whoops
litigation.
scandal. Yes.
Yeah, which turned out, of course, to be a horrible investment. I mean, business-wise, to be a horrible investment. In Britain, the House of Lords ultimately determined that the municipalities within the Greater London region lacked the power or lacked the authority to make investments in financial derivatives, which also then, after the fact, turned out to be very bad investment decisions from the standpoint of the investors. So, I mean, so in other words, another function here that we observe that central government serves is through the court system and through judicial declarations after it is known just how bad, in economic terms, the decision was for the municipality, that the municipality in fact lacked authority. So, a question that leads to my point was suggested by something that Jake said, which is central government involvement as a form of bonding or a form of commitment advice. Because one of the things that these examples maybe would illustrate to creditors is that commitment in this field is a tricky one, and trickier than in private borrowing. Whereas it's a fairly straightforward question whether the corporation has authority or not to issue a particular kind of debenture or bond or preferred stock or whatever. But legally there seems to be more risk here of kind of supervening legal illegality, which is maybe another, just kind of like, in a way, it's kind of the flip side of a central government bailout, right? And this is basically central government nullification via the judicial system of the debt itself.
David, can you hear us okay?
I was having a lot of trouble hearing her because it's a little away from the microphone.
Okay, well, let's see, do we want to get that here? Yeah, that would. Yeah. The question was whether there's another central government, or an observation, there's another central government involvement, which has been illustrated both in the U.S. and UK, judicial declaration that the subnational unit lacks the authority to issue the debt, for example, as happened in the Whoops bond issue in Washington State, and happened also in London. And Professor Deborah DeMott, I think, made an interesting observation. I have a question for Professor DeMott, and that is, if you have a system, is that a corollary, basically, of the concept that I've discussed, where you have where the central government restricts the issuance of the subnational debt, like in Japan? Because if you didn't have that restriction, then what would be the basis for the judicial unit to basically decide? And if you do have the restriction, of course, you would presumably enforce it. In other words, is it really part and parcel of this issue? Does it go beyond the restriction I discussed?
Well, I think it's a function of the fact. I would think it's a function of the fact that sub-sovereign units are not fully sovereign. I mean, that is to say, they have the power, they have the authority conferred upon them by statute or conferred upon them by a state constitution, for example, or by state legislation, but they don't have the kind of plenary power or plenary authority that we'd associate with a fully sovereign unit.
Professor Gelfand, do you have any questions you'd like to ask or any comments?
Yeah, I had three see if I can sleep through them. Professor Schwartz, on your discussion about moving to supermajority voting as opposed to unanimity,
Right.
I assume that you'd be talking about future debt, because wouldn't you face at least in our country, a contract clause problem by changing the move from unanimity?
Well,
And once your law is in place, it would be just like the bankruptcy code.
right. In fact, I do intend the supermajority voting to be retroactively imposed. And in the paper towards the end, in the implementation section, that addresses binding creditors, I spend a number of pages, and I did not address it in the talk because it's fairly technical, but I do address it in the paper, and this is, at least in the draft I have before me, which David is probably several drafts from what you have. It's, it's part, let's see, it's part 4C1.
4B1?
4C1, C as in cat,
Okay.
under binding creditors, and
Basically, I assume you just take the position that it's a remedial change rather than a substantive change.
no, I say it's a substantive change. I mean, it is a substantive change, and I say an issue might arise, however, where enactment of the model law, could be retroactively applied, and I look at that issue under both. I mean, I say as a question of domestic law, it's going to be a question of the domestic law, but I do analyze it under international law because it would bind foreign creditors, and conclude that at least international law does respect the retroactive effect in limited circumstances, and I argue that the circumstances here do fit within the limitations, so the retroactivity would be sufficient, would be okay. I also argue that retroactivity would be needed because of the fact that many debt restructurings you would have existing debt obligations. Municipalities can issue debt that may go for 10 to 20 years in some cases.
Right.
And so you would really need to address retroactivity.
And your solution to the contract clause problem is what?
Well, in terms of the contract clause, you mean under the U.S. Constitution?
Yeah.
The Supreme Court, when it's not involved in political issues,
Right.
has ruled that the retroactivity is sufficient. It ruled this under the U.S. Bankruptcy Code, or in fact under the predecessor of the Bankruptcy Code, which did apply supermajority voting on a retroactive basis.
Well, you're talking about the Asbury Park case.
Actually, I'm not sure what cases I'm talking about. I'd have to go back and check it.
Right.
But I do.
Well, I just wanted to highlight that question. If you've addressed it, I assume I'll be getting an updated copy of your paper.
I will send you one after this session.
I mean, that's been, I raised that because it's been a matter of concern in some of my writing and in some of the cases that I've been involved with. After U.S. Trust, I think it becomes more difficult to make retroactive changes that you acknowledge are substantive. I don't think it's impossible to overcome it, but I just did want to make sure that you spotted it, thought about it.
Yeah, no, I have. And what I'll do is I'll also, in the piece I wrote on sovereign debt restructuring, published in the Cornell Law Review, I had, as I recall, a more complete discussion of this issue. And in fact, what I may do is, when I go back and check the Subnational piece, if the discussion is not as complete, I'll send you the relevant discussion from the sovereign debt restructuring piece.
Okay,
And then I'd be happy to discuss it and get any comments you might have.
Right. Yeah. Let me read that rather than try to waste other people's time, because as you say, it's pretty technical for folks who aren't wasting their time on these issues. But I just thought it is a potential stumbling block, and I agree with you. It is something that you're really going to need to want to implement for existing debt if there's a way to do it.
Right.
Now, that sort of segues to my next question, which is when you were talking about implementation, and you talked about central government, do you foresee in a federal system like ours or Australia's or Canada's that this would be done on a state-by-state or province-by-province basis, or do you see it as literally the federal government?
When I say central government, what I generally mean would be the national government.
Right.
But of course, in a given country, it could be done at different levels. So that, for example, a national government, let's say, could delegate the implementation, administration responsibilities to scrutinize against overinvestment. It could delegate it to a state regarding municipalities within that state. But if the state were the one that were in trouble, then the central government itself would be the only logical, assuming there's no level between the state and the national government. But I did not get into the details of that. But I think I ought to. I think that point is well taken.
Well, the reason I asked the question is let's assume for a moment we're talking about local government, cities, and let's assume for a moment we're talking about the United States. I think, given the Supreme Court's recent federalism jurisprudence, other than what they're doing in selection process, we've got aside from that, but all the other cases that have come down in the last few years, I think would pose some potential problems with federal government intervention. I mean, if you recall, when they first tried to pass a municipal bankruptcy code, there was some concern.
Yeah, that it would be unconstitutional.
Right. And so I'm a little concerned about, insofar as those same principles have been withdrawn, and we're talking about a state. Now, of course, you cover it partly because you say it can only be voluntary. And as you know, our current municipal bankruptcy code, a city could only do it with the permission of their state. But I just think there are some difficult federalism questions that need to be addressed there if you're going to have the federal government acting. But conversely, if you don't have the federal government acting, and you've got to have every state adopt this, you're not going to have as effective a program from an economic perspective.
Right. That is true. Somewhere in one of the footnotes, I actually go through this,